Y'all bow with me. Most gracious and heavenly Father, Lord, we thank you for this day you've given us, Lord. We thank you for the opportunity to live in the greatest country on the face of the earth, Lord. Lord, we ask that you be with us as we go throughout the day's business. Lead, guide, and direct us in all that we do. In Jesus' name I pray. Amen.
Amen. We'll go ahead and call Marshall County Fiscal Court to order December 17th, 2019. Got a large crowd here. I see Greg back here. Greg, you want to come on up? You're first on the agenda, sir. We're going to get an update from Greg Carlton on our senior citizens. Good morning. Yeah, come on up, Ken.
Good morning, Judge and members of the court. I want to introduce Miss Jonah Williams and Miss Dee Dee Guthrie. Mr. Ken Lewis as well is with us. And we have many other supporters and folks that have been working hard for the senior citizens that couldn't be here this morning, but thank you. I know you've got a full plate today, so I'll be brief, but I felt like the court deserved an update on how we're doing. I know months ago, the court was very supportive in continuing efforts of the senior citizens and its organization and center. So I just want to bring you a few updates this morning and share with the broader community what's going on so that we can show will benefit Marshall County as a whole. First of all, a formal thank you to Marshall County Fiscal Court Judge, Deputy Judge, and Commissioners for their support, not only financially but also many calls and visits and coming to be with us. During the last few months, we've had on average over 50 supporters at any given time coming to the regular weekly meetings. These folks are, I would summarize it as saying they're listening, they're supporting, they're advising, they're donating ways to improve the life and the care that we can give as a community for seniors, and not only seniors, just to be a caring community. You're going to hear that term come up again just in a minute. In addition, so we've created a regular weekly schedule. So we felt like it's important to meet every Wednesday at 9 a.m. just to stay on top of this sort of re-grand opening, rebirth of the senior community. We're sharing our meetings notes every week with the entire group and anyone that wants to see them. The new city attorney, Rob Mattingly, has been very instrumental in helping us get new bylaws, amended bylaws up and going and answering just organizational questions. Mayor and the judge both have been very supportive and given a lot of their time, calls, and visits. Many of the other court members and city council members have also been in attendance and supportive. I will say that recently Deputy Judge Warning and I did a visit on site and inspection of the building and the needs of the Marshall County Senior Building for the future to start planning ahead. And in specific to the building, I want to tell you, if you haven't been to the Marshall County Senior Building on Golf Course Road, find time to come by sometime and visit, because we've had the roof patch thanks to the fiscal court. The floors are stripped and refinished. We thank you to Miss Jonah Williams for leading that charge, for Jailer Roger Ford for his leadership and helping bring some of the inmates to donate their time and help with that project. And the floors look amazing now. New paint inside and a fresh look. We had a gracious donor who donated money for paint, and we hired a local painter to help us get the refresh look going. Exterior we've cleaned up landscape. Fiscal Court helped us with a new drainage tile to keep the water out of the building, which has been a blessing, obviously. So updates in terms of the structure. The current board will be nominating new board members and a new executive committee, and then we'll have a subcommittee group that's going to be comprised of leaders and individuals from across the entire community. And so it'll bring the entire community together through this. We're working now on future plans to fundraise, because obviously it's important in this day and time not to rely on fiscal court and other funding. We want to be self-sustainable. So we're going to be working on all kinds of fundraising activities. A relaunch of the senior citizens as a brand is going on. I mentioned the name Caring community. Well, we're going to be known as the Marshall County Senior Citizens Caring Community Center. So it is in keeping with how caring Marshall County is as an entire area and a community. And it'll be a DBA of the organization. We've already got our new social media page up and going, so if you want to go out and look at Marshall County Senior Caring Community, you can follow that. We've grown by hundreds in the last few weeks since we launched it. We are going to be filing for a gaming license to have bingo, and so we'll hear more about that. It may be a little controversial at times, but we'll work through that process. But that's one of the ways we're looking to raise money and have fun at the same time. And we are planning a re-grand opening for January 8th at 11 a.m. to 1 p.m., and we'd invite the entire community, especially the Fiscal Court and all the members of the court and the City Council and everyone else that supports us politically here. So we welcome your comments, questions. Again, we just want to say thank you. And I'd just end with this. Whether you stand or you show a hand, if you know someone who, what we would call senior, I'd say that's at least 50, maybe 55 or older. If you know someone, if you've had a family member, if you are that age, you got a mother, father, grandfather, grandmother, aunt, uncle, whoever, raise your hand or stand up, because I think this affects every one of us in every community, right? So it's so important that we come together as a community and support this cause, and thank you very much.
And I know the court wants to recognize you, Greg, and Jason Jones, and some of the others from the community that have stepped up to make this happen. And that's really what it is. It's getting people from the community to step up and make this happen. So we want to recognize you for the efforts that you've been doing, too.
Amen.
Yes, sir. Thank you.
Thank all of you. Thank you.
Yep.
Thank you. Have a great day.
All right, we'll move on to item B. I'm going to read a bio real quick on Dr. Fennell. He's sitting in the front seat here, but I'm just going to read this to introduce him. Dr. Fennell is a native of McKees Rocks, Pennsylvania, and currently resides near his hometown in greater Pittsburgh area. He received his Bachelor's of Arts in Philosophy from Washington and Jefferson College in 1990, a Doctor of Medicine degree from the Pennsylvania State University College of Medicine in 1994, and a Master's of Public Health Services Administration in 2008. Dr. Fennell completed a residency in anatomic clinic pathology at Walter Reed Army Medical Center and a second residency in preventive medicine public health from the Uniformed Service University of the Health Sciences. Dr. Fennell retired in July of 2016 from the United States Air Force in the rank of colonel. Appreciate your service. Dr. Fennell is a staunch advocate for the right to keep and bear arms for over 20 years. He was the first president of the Virginia Citizens Defense League, a statewide grassroots organization dedicated to the right to keep and bear arms. He is also a life member of Gun Owners of America, the National Rifle Association, and Firearm Owners Against Crime in Pennsylvania. He belongs to the Allegheny County Sportsman's League and Corpus District Sportsmen's Association. Having lived in the Washington, D.C. area for over 8 years, Dr. Fennell was trained by some of the finest conservative minds in America. This included the grassroots activism training at Gun Owners of America, along with being a graduate of several Leadership Institute courses. He is a life member of both the Military Officers Association of America, Disabled American Veterans. Dr. Fennell serves as the National Chaplain for the Italian-American War Veterans and is a member of the American Legion. Dr. Fennell currently serves as the Pennsylvania Director for Gun Owners of America, the only non-compromised gun lobby in Washington. He is leading a statewide effort to establish Second Amendment sanctuary ordinances across Pennsylvania and is here to talk to us today about the significance of this movement. So I want to personally thank you for coming today to address some of these issues to the folks in this county. So, yes, sir.
Okay, hear me okay?
Yes.
All right. Judge Neal and the Commissioners of the Marshall County, Kentucky Fiscal Court, thank you for inviting Gun Owners of America to speak at the consideration of an ordinance establishing the first Second Amendment sanctuary in the Commonwealth of Kentucky. Make no mistake about it, the enemies of our Constitution are out to take firearms away from law-abiding citizens. Just look what is happening in Virginia. The ink had not even dried on the election results, and the Democrats pre-filed bills to enact draconian gun control legislation. What can freedom-loving, law-abiding citizens do to protect themselves from the anti-gun juggernaut of politicians who hate our constitutional liberties? What can be done when the deck is stacked in at least 2 out of 3 branches of government? And notice I said at least 2 out of 3. In some places, it's all 3. Clearly, someone has to stand in the gap between tyranny and liberty. Someone has to interpose themselves between elected officials who have total disregard for constitutional rights and the citizens they are supposed to represent. And that's what we are seeing happen in the Old Dominion. County supervisors and sheriffs are standing in that gap. They are interposing their authority and are refusing to enforce unconstitutional gun control laws. At last check, and this changes so rapidly, some 85 jurisdictions have passed Second Amendment sanctuary ordinances, or SASOs, we say SASO for short, in Virginia, and more are on the way. Nationally, as of November 18th, 2019, some 240 counties, cities, and towns have passed SASOs in 19 separate states. Illinois, Colorado, New Mexico, and Washington have passed them in a majority of their counties. Without these officials standing in the gap, citizens would be left to themselves to protect their God-given rights. Unfortunately, many of these counties in Virginia and elsewhere have passed meaningless resolutions. While they are certainly well-intentioned, they simply don't have any legal consequences built into them. Instead of resolutions, counties and municipalities should pass sanctuary ordinances that carry the full force of law. To that end, Gun Owners of America has created a model ordinance that has teeth to protect the liberties of citizens. GOA's ordinance prohibits the use of local funds and the enforcement of unconstitutional gun control laws. It contains civil penalties for any violation of the ordinance. Any peace officer can enforce GOA's ordinance. Finally, anyone violating the ordinance can be sued in court with no sovereign immunity protections. The ordinance describes unlawful acts, which include such things as taxation, registration of firearms, accessories, or ammunition, registration of owners, gun bans, gun accessory and ammunition confiscation, and magazine capacity restrictions. I want to congratulate the Marshall County Fiscal Court for considering GOA's ordinance as the model for your Second Amendment sanctuary. I would hope that Marshall County sets the example for what every county in Kentucky should do to protect their citizens from unconstitutional laws, whether in Washington, D.C. or Frankfurt. And by doing this, counties across Kentucky and in other states are standing upon a well-respected legal tradition going back to the time of the Roman Empire, known as the doctrine of the lesser magistrate. A lesser magistrate is an elected official who uses their authority to interpose themselves between the unjust edicts of a superior in order to protect those in his or her jurisdiction. The Roman Emperor Trajan handed a sword to a subordinate and said, "Use this sword against my enemies if I give righteous commands. But if I give unrighteous commands, use it against me." In the 4th century, St. Ambrose blocked the Emperor Theodosius from the church entrance until he repented of the unjust slaughter of political enemies in Thessalonica, and he did. Western Christian civilization furthered this doctrine. In 1215, when the nobles stood on the field of Runnymede and forced the tyrant King John to sign the Magna Carta, they stood between the people and the sovereign's oppressive edicts. They restricted royal power and reinforced that the king had limitations. A little later that century, St. Thomas Aquinas expanded upon the natural law theory of the Roman jurists. The angelic doctor taught us that man-made law could not violate either God's revealed law or the natural law. If it did, the law was no law at all. Moreover, such a law must be disobeyed. Again, we see here a limit placed upon human law and the justification for that disobedience. We see natural law theory being used in the Declaration of Independence, where Jefferson speaks of truths that are self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. And it is the duty of government to protect and secure those rights, not grant. The government can never grant a right. For if it could grant a right, it could take it away. No, legitimate government exists to protect and secure those rights. And when it doesn't, it ceases to have legitimate authority. All of us are Americans. We believe this, or else our country would not exist. American jurisprudence has always taught and assumed this doctrine of interposition. Black's Law Dictionary defines interposition like this, quote, "The doctrine that a state in this case, in the exercise of its sovereignty, may reject a mandate of the federal government deemed to be unconstitutional or to exceed the powers delegated to the federal government. The concept is based on the 10th Amendment of the Constitution of the United States, reserving to the states powers not delegated to the United States," end quote. Unfortunately, I believe we need to expand Black's definition of interposition to include counties resisting the unlawful mandates of their state legislatures. So Marshall County is standing in this long line of legal reasoning of interposition. By adopting a say-so, you are upholding the supremacy of the constitutions of Kentucky and the United States. Anyone who would seek to take away our God-given rights is violating the supreme law of the land. By passing such an ordinance, you would be upholding the three duties of a lesser magistrate. 1, first duty, opposing any law that goes against the Constitution. 2, protecting the life, liberty, and property of citizens in your jurisdiction. And 3, by not implementing any laws that violate the Constitution, and if necessary, resisting them. Do not let anyone tell you that this fiscal court would be violating state law. Rather, you are upholding the higher law. If the state legislature or Congress hands you unconstitutional gun control legislation, it is they who are breaking the law. The Constitution is our objective standard of what is acceptable or unacceptable, not the whims of anti-gun politicians. I have not held elected office, but I served my country for 20 years as an officer of the United States. Military personnel and elected officials both take an oath to defend the Constitution of the United States, and the oaths use similar language. Here's what the officer's oath says. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Note that our oaths of office, whether military or elected officials, do not involve swearing allegiance to a person, a king, a particular government, a governor, fill in the blank. No, the allegiance is to the Constitution. And when an order is given that is unlawful, it is my duty as an officer to stand in that gap and refuse to obey. Likewise, it is your duty as elected officials to do the same when our essential liberty is being trampled upon, whether in Washington or the state legislature. Notice also the last 4 words of the oath, "So help me God." Sometimes we gloss over those words and treat them as pro forma, but they are very important. When we say, "So help me God," what are we promising? Are we just entreating God's help for the oath we took? Yes, but it is much more than that. When we say, "So help me God," we are swearing that we will uphold the oath. Swearing. That means we are asking God to judge and condemn us if we violate it. That is why oaths are sworn. We either obey this oath or God judges us. That is very serious. It means that we uphold that oath, even when it places our personal livelihood and position in jeopardy. But sadly, most politicians don't care about that at all. Some skip it altogether. That is another reason why adopting a Second Amendment sanctuary ordinance is so striking. You are showing that you intend to uphold your oath of office, regardless of what consequences it will lead to politically or even personally. By choosing to interpose yourselves between liberty and tyranny, between freedom and oppression, you stand in the gap just like our forefathers did in 1776. And standing in the gap not only protects those in your jurisdiction from unjust laws, but it actually spares our country from God's judgment. Ezekiel 22, verses 30 to 31 says this, quote, "I looked for someone among them who would build up the wall and stand before me in the gap on behalf of the land, so I would not have to destroy it, but I found no one. So I will pour out my wrath on them and consume them with my fiery anger, bringing down on their own heads all they have done, declares the sovereign Lord." Will our Heavenly Father find no one in Kentucky to stand in the gap and thus invite God's judgment? Or will Marshall County and other counties in this state interpose themselves to save this Commonwealth? May God give you the courage and conviction to stand in the gap. Thank you very much.
Thank you, Dr. Brennan. Just a show of hands, who would stand in that gap? Now, this ordinance is going to have a lot of controversy. Already we know that there's some legal opinions, but this ordinance, I think, has been drafted in a way that it covers some of those legal concerns. We currently have a statute, KRS 65-870, that the commissioners were made aware of, and there are consequences, potential consequences for this fiscal court. But at the end of the day, this ordinance, we're not regulating under that statute. And I know we've talked about it. It's hard to believe that we have to actually look at putting an ordinance in place to protect our God-given rights. But this ordinance, we need to discuss this and put this out on the table so that not only folks in our community understand what's at stake, but across the state. I know that several leaders across the state in various counties have already reached out to me. They're concerned. They've seen some of the pre-filed bills within our legislation, and there are serious concerns that citizens have. And as an elected official, I think it's our responsibility to at least bring this to the table. I'm not going to wait and wait for the General Assembly to pass more laws or interpret statutes that are already on the books. This discussion needs to be brought to the forefront. Is it going to be a tough discussion, potentially a battle, if you will, to get this resolved? Sure it is. As Dr. Fennell says, the first one through the gap. Marshall County's first one through the gap. We're going to be challenged. But if we don't stand up and challenge what we believe in, what's already been given to us, then we're never going to know. And I'm not going to stand by as an elected official, and I know, I believe some of the other elected officials feel the same way, and watch us have our rights stripped from us. I know this is the first reading of an ordinance. We had a resolution, but a resolution simply just doesn't have any teeth. This ordinance, we're drawing a line in the sand just so that you understand what this is. We're drawing a line in the sand to have this debate finally, to put this to end, that we do stand behind our constitutional rights. One of the concerns, and I'd like to discuss it today, is that statute 65870. You know, I reached out to a constitutional attorney, and the reason why is because I'm not a constitutional attorney. This is new. It's hard to understand that this is new, that we have to fight for our rights. It's not new for our country, but it's new for us today, that we have to fight for this. And we have to have these discussions. But I think that the legal opinion under 65870, and we put this in the ordinance, we'll read this here in a minute, but I think that it covers that. It outlines that we're not regulating under that statute. And I may have the county attorney explain the regulation of that statute from a legal opinion. What we're simply saying is those unlawful acts under the Constitution, that you already have those rights. As Dr. Fennell says, it's our responsibility to protect those rights. You elected us as elected officials. You have those rights, and it's our responsibility to make sure that they're not infringed upon. So that's why we have this here. And that's why we're going to have this debate. We're going to have this discussion. My intent is to send this out to the other judge executives across this state. They can do what they want with it, but my intent is to get this to the other counties within this state so that we can send a loud message to our representatives in Frankfort that we're serious about this. And I would open the floor for that discussion on that statute, because I know that was something that was sent to the commissioners and myself, as far as that this ordinance on its face value is an illegal ordinance. So, do you want to comment on that?
Well, the ordinance itself, you have a copy of it?
Yeah. Look at section D5.
You had mentioned in your email something about possibly changing after talking to the constitutional. Is this any different? Did anything change?
The one that she sent out this morning has got the changes.
Okay.
So you should.
Section was
Section D.
5. Is that what you're?
Yeah. It
Who
specifically
drafted
states
this?
65. You just heard him.
Okay.
Yeah. This is something that is going on in Pennsylvania. That's why I had Dr. Fennell come here, is because this isn't just exclusively to Marshall County or Kentucky. As he mentioned, look at Virginia. You know, these are the same concerns that they're having in Pennsylvania. The problem is that this is not a one-size-fits-all. Every state is different. You know, you look at our Constitution, the state Constitution. We added that Section 1 into this ordinance, as we swore to an oath to uphold the state Constitution as well. And this ordinance is not to, it's to put on our employees, because it's your individual rights that you have through the Constitution. So the argument, I believe, was regulating that statute. And I think some of the examples that were used, that's not what we're doing. That's absolutely not what we're doing.
Well,
Are you fine?
There's a couple problems that I see with the ordinance. Number one, I'm just going to read the definition here of what constitutes an unlawful act under this ordinance shall consist of any federal or state act, law, order, rule, or regulation which restricts an individual's constitutional right to keep and bear arms, including any federal or state act, law, order, rule, or regulation that bans or effectively bans, registers or effectively registers or limits the lawful use of firearms, firearm accessories, or ammunition. I don't think it takes a constitutional scholar or even somebody that went to law school to say that, and it goes on to say that an unlawful act is considered null and void and of no effect of Marshall County. I mean, that we have no authority to declare a state statute or a federal statute null and void in Marshall County. I mean, you can put it in writing, but it has no legal effect. So that's one problem with it. The other problem with it is that Section 4, you are creating penalties for our deputy sheriffs if they enforce state statute. And I'm not aware of any statutory authority that allows this court to do that. When a local government acts, it needs to act with authority from the state government because that's where the authority comes from. The state giveth and the state taketh away. And if there's not authority to put this in there, then it's an invalid act.
And I think that the actual intent of this ordinance is to penalize those that infringe upon the constitutional rights. Now, how that's drafted, yes, a constitutional attorney did look at that, and those opinions, let's face it, attorneys have legal opinions. But the intent is our employees are not going to enforce laws that are unconstitutional.
You control the purse strings. So if you want to tell Eddie, as the sheriff, that you don't want your tax dollars spent,
And that's in there.
then you can tell him that. But you control the dollars. You don't control, as a constitutional officer, you don't control what he does or how he wants to emphasize his enforcement of state statutes. I mean, that's his decision to make.
Right. And
You can arguably you could withhold dollars from him if he doesn't do what you wish for him to do. But at the end of the day, that's a decision that he makes.
right, and that's in there.
No, you're creating a place for them to be sued and to face civil fines if they enforce state statute. And that's at the whim of whoever gets arrested. So
Okay.
you're opening up this court and those deputy sheriffs to be sued.
And so through the breach we go. And that's what I say. This ordinance, there are going to be opinions. I'm confident that this ordinance is sound. And if we end up in the court, if we are sued, I mean, that is a possibility. We don't expect that not to happen. But at the end of the day, if we are actually seeing rights that we have under the Constitution violated or infringed upon, we've got to put a measure in place to protect the citizens in this county that doesn't happen. So, I mean,
And I did also reach out to Rich Ornstein, who's the local government attorney for Keiko, had him review it, asked for his opinion, and he also had the same thoughts that I did, that it has serious problems.
sure. And Rich Ornstein is the representative for Keiko, which is our insurance company.
He's an attorney as well.
Yes, and we can get into the legal what ifs. At the end of the day, the legislation in this state, some of the bills that are being put out there, the constitutional rights that citizens have in this county are being infringed upon. And where is that barrier? Where is that governing body that's going to stand up and protect those rights? Now, we can definitely get in. I'm not an attorney, and I'm not going to get into the legalities of it, but we definitely can. This is the first reading. That language can be changed if it needs to be. But we definitely need to stand up and make sure that the rights under the Constitution for the citizens in this county are not going to be infringed upon. And however we have to get there to make sure that doesn't happen, this is the first step. And that's the intent behind this. Obviously, there's a lot of folks that feel the same way. How we get to where we need to get to where we do not infringe upon the rights of people in this community and across the state, for that matter, that's where we're at. So this is a first reading, and a first reading, as long as it's not substantial changes, to my knowledge, first reading of the ordinance is just the first step to get there. The issues and concerns that was addressed to the court was 6578 as far as regulating that statute. But this ordinance, the way it was explained to me, is not regulating that statute.
Well, I mean, just because you put a sentence in there that says it's not a regulation doesn't mean that a court's going to agree with you.
Sure.
I mean, you've got a whole list of definitions in there talking about various aspects of possession, ownership, transfer, sale of firearms. And you're creating a new cause of action against the deputy sheriff if some person feels like that their rights have been infringed, then they sue the deputy sheriff and probably sue the county. And there's no statutory basis for that. So you are, in fact, regulating firearms.
And that's, as the section
Call
is
it
written.
regulation, call it deregulation,
Yeah.
whatever you want to do. If you can't find a statutory basis for it, then it's not valid under Kentucky law.
Yeah, and that actually happens at the act, correct? So the actual individual has to act upon that for that to actually occur,
Well,
correct?
there's civil fines in there as well.
Well, sure. I mean, you have to put some teeth into that.
So who decides what's an unlawful act?
Well, it's outlined in here. This ordinance is specific on that.
Anything?
No, it's outlined on here.
No, it says any law that you don't think is constitutional, they're subject to a civil fine.
No, that's not how this reads.
Yeah, it says any state law, any state or federal law that infringes upon the right to bear arms.
Well, sure. I mean,
According to whose standards?
If there are, well, we're elected officials, and if we have citizens whose individual rights to carry firearms, we outline in this that we're not going to have our employees infringe upon those rights.
So, yeah, a court decides when a right has been infringed upon.
Sure.
Not this body.
Sure. But I mean, this ordinance, again, is the first step to make sure that
And
that
different
doesn't
courts-
happen.
Different courts have different views of it. Different circuits have different views of it. Different states have different views of it.
Yes.
So there's no uniformity whatsoever.
Well, in the attempt to get an ordinance in place, it sounds like to me that there's more discussion of we can't do this. Are you saying that we can't put a sanctuary ordinance in place?
Yes.
Okay, so you're saying that we can't put a sanctuary ordinance in place?
Not imposing penalties on a deputy sheriff for enforcing state law.
Okay.
As I said before, if you want to adopt a policy with regard to money spent to the sheriff's office and tell Eddie that, okay, you do X, Y, Z, you'll get funding, then that would be a legal act. And then it's up to him to decide whether or not how he wants to run his office.
No.
But you're creating a penalty, a new penalty without authority.
Yeah, I know that, reaching out and speaking to a well-known constitutional attorney on this, and I respect that you are an attorney, but I don't think that we are bound not to put something in place like this. Can it be challenged? Yes, most definitely. And that's where we're at. We are not trying to be the General Assembly. What we're trying to do is protect the citizens' rights in this county. And I can tell you from my experience, you can have multiple attorneys and you have multiple opinions. The first step that we were trying to do is to get this in place to where we make it known that we're serious about the constitutional rights under the Second Amendment. and then they're not going to be infringed upon. You know, this document, none of us are attorneys as far as drafting this, but this was drafted by folks who are attorneys. Are there opinions? Sure. You know, the request from your office was to explain, take a look at this, and under 65-870, you know, your opinion is that it's regulating. The other opinions of the other attorneys are that it's not regulating. That tells me that there's an issue, and if it is going to be decided, it's going to be decided in the courts. And if that's the route we have to take, then that's the route we have to take. Our attempt is to put the best ordinance that we can in place so that we can have this in our county. I mean, this is the first reading, but I think people understand the significance of this. The intent's not just to come in here and read this and then walk away. I mean, this is serious issues that we have to have these discussions. Is it uncomfortable? Sure it is. But we shouldn't be uncomfortable when it comes to protecting our rights. Do we have to navigate the legal opinions in this state? Yes, we do. You look at Pennsylvania. You know, they pass ordinances and the courts throw it out. The very next day, similar ordinances for other political, you know, divisions, they pass them and the courts choose differently. That is occurring across this country, and it's got to stop. The Constitution is the Constitution. We either uphold it or we don't. And we've gotten to a point in our society where this right here is that, you know, elected officials, these folks here elected us to take these steps to protect these rights. However we have to do it, we're going to do it. That's the message. If we have to draw a straight line, we draw a straight line. If we have to put language in here, then we'll put language in here. But my problem is we need somebody that has a constitutional background to help us get there. And that's what I at least tried to do, is to get a constitutional attorney to draft this or at least look at it. Obviously, our intent is not to break a law. But I tell you, if there's a law that is written by the General Assembly that is unconstitutional, I'll break it every day, because the Constitution is the law of the land. You know, this back and forth is I've had enough of it. You know, we're going to get this ordinance drafted the way it needs to be drafted. We're going to, you know, the legal opinions, that's where I think it takes a curveball. At the end of the day, you cannot infringe on the Second Amendment rights. We can discuss all day about the county sheriff's department and putting law enforcement in compromising situations. As a former retired police officer myself, I've seen constitutional rights violated. It happens. We have to get that in our heads. This happens on a daily basis because of the human element. You know, we're all humans. We make mistakes. But the one thing that is going to happen, or that we need to do, is we need to put something in place that we stand up and we say we've had enough. Because if we don't, before we know it, it's going to completely change, and it has changed over the years. And before we know it, those rights are going to be stripped away from us, and we'll never get them back. So how we navigate those political waters, that's what we're going to have to do. That's what we're being asked to do. You know, I'm not going to entertain the politics of it, because that's not where we're at. Now, after looking at this and reading this, if there are serious concerns, then the legal attorneys need to sit down and discuss those issues. But the intent of this court is not to violate laws purposely. You know, that's why we have attorneys. It's a love-hate relationship, but that's why we have attorneys to help us navigate those waters, and there's different opinions on both sides of the aisle. And this is the first step, in my opinion. Is there any other comments by anybody?
Question for Jason. This 65,870, is there any way you see that we could modify the ordinance to the point where we wouldn't really make a big change to it, but still adhere to the 65,870?
Yeah, you make it a policy. You don't make it an ordinance that creates a penalty for the deputy sheriffs. You make it a policy where, and that's what, when you're changing gears here to these sanctuary cities, that's what they've done. They've said, we're not going to allocate resources to cooperate with the federal government for immigration enforcement. That's fine. They don't have to. They don't have to cooperate. That doesn't invalidate the law, though. As the purse string holder, you can tell Eddie, as a policy, don't do this X, Y, or Z. If you do, we're going to pull your funding. And then he has a choice at that point in time to say what I'm going to do as the constitutional elected officer as sheriff.
Now, it's my understanding that as far as the correspondence, it was stated that it was specific to firearms, that the counties can in no way put an ordinance in place specific to firearms. When we're talking about sanctuary communities, and let's face it, immigration sanctuary, there's a pre-filed bill on immigration sanctuary communities. That's a whole nother subject matter because, in my opinion, immigration, if you're here illegally, that's a totally different matter. We're talking about legal citizens who have constitutional rights. But the concern, too, that this ordinance needs to take in place for the citizens is that that pre-filed bill is going to discuss creating new chapters, changing existing chapters to where there's local governments, how they can or can't put sanctuary policies in place. That is actually what is pre-filed right now. And nobody knows what the language is. Nobody knows what the outcome's going to be. I know as an elected official, when we go to our conferences with CAECO, they just put out a big survey. They wanted to hear from elected officials what are the concerns in their communities. Nothing about sanctuary policies was mentioned. But then all of a sudden we have pre-bills filed. If this statute is deemed a specific statute for local communities regarding guns, you have immigration ordinances. Jefferson County is one of them, where they have an immigration sanctuary policy or ordinance in place, but there's no statute, to my understanding, on the immigration issues. Are you aware of any statutes? Are you saying that this statute, they fall under the same preview for?
No, the only reason I brought that up is to explain what these other cities are doing. I'm not talking about Louisville, I'm talking about around the country. They're adopting policies where they don't devote resources to cooperate with the federal government. And what in response to Kevin's question was how do we do this? How do we establish this legally? And that's my opinion on how you do it, is you establish a policy that from a financial standpoint, that you're not going to devote resources to Eddie's office for enforcement. And then he has a decision to make, okay, do I accept these dollars or do I not?
And that policy cited in this ordinance.
Right.
But my concern still is that these pre-filed bills regarding sanctuary policies at the local level, that is a discussion at the General Assembly that's, I don't even know if it's going to pass, but, so that the folks understand that they are having these discussions and how that's going to affect us here with our intent with a Second Amendment sanctuary community. You do have policies that are out there, ordinances that are out there in this state regarding immigration, and the General Assembly is going to be taking up the whole issue of sanctuary policies.
It's similar. Let me give you an example. It's similar to how the federal government interjects itself into, for one example, the legal drinking age. Mm-hmm. Around the country, it's 21. Why is it 21? Because the federal government says if you want highway dollars, you make the legal drinking age 21 in your state. Kentucky would be free to make it 16 tomorrow if they wanted to.
Correct.
They lose federal highway dollars. So the federal government puts that carrot out there, make it 21, you get your federal highway dollars. That's what this court can do, even though they can't make Eddie do this or that,
Right.
enforcement-wise. You hold the purse strings, so you can have incentives to do this or that.
Right, and Department.
That's the way that you implement your policy in regard to this ordinance.
Right, and Department of Justice on the sanctuary, that, ordinance that was in Jefferson County, that's exactly what they did. They basically itemized certain parts of that ordinance and said these federal dollars are in potential loss. They may lose those dollars from the federal government. So this ordinance, putting a policy in place, then, are you saying that covers your legal opinion of it being legally binding?
Yeah, I mean, that would, the problem that I have is that you're creating a penalty for the deputy sheriffs without authority to do that. But if you want to implement the policy, that's the other way to do it is what I just explained.
Okay, and definitely then we will look at putting a policy in place in this ordinance if that's all it takes. Is there anything else in this ordinance that you see that might be?
No, I mean, and as a defense, to me, I just got this yesterday, and I had a full day of DUI court and traffic court, so I have had limited time to deal with this. But I have been researching, and I have been talking to Rich Orenstein, and that's the way that I see to fix it legally and still accomplish the same goal that you're wanting to do.
So you could add that policy in the ordinance, I understand you correct on that?
Yep.
Okay.
Do you have the actual pre-filed, have you seen the actual pre-filed bills?
For which one?
Well,
The ones I've referenced?
yeah, they're
Yes.
actually pre-filed on LRC.
Yes,
Okay.
they're on.
Do you have the numbers, or
57.
357?
Yeah.
Senate or House, or is that?
Both.
I can't remember.
Both. It's, yeah. I mean, there's one with registration of firearms. There's red. Yeah, I can get them to you. I think
Well,
there's.
it's okay. I mean, I can look it up.
I just think it's important for the citizens to know that there are pre-filed bills, and these discussions are coming up. And, one of the other things is that's why we're here today, is to get this out in the open, so that when they are having these discussions, I plan to have, trips to Frankfurt so that we can sit in some of these committee hearings and let our representatives know that, the folks back home are going to be paying attention on how they are writing these policies or these laws. I don't know if these bills are going to pass or where they're going to go, but I think it's time that this is what's got to happen at the local level. We've got to get together. We got to get the people informed so that they understand what's going on, and that collective communication between each of us, so that that we're not going to stand by it. We're going to fight it in Frankfurt, and it's going to be a fight. You all know that. I mean, you're on the receiving end of it. But these bills that are being presented, we need to communicate back to our constituents, and my intent is to get it across to the judge executives across the state so that they understand it as well. That they've got to get that information back to the citizens in their community. But we can do that. We can add a policy, put that in here, and put more teeth into this. Resolutions, as I stated earlier, they just don't have, and I think Dr. Fennell hit the nail on the head. As an elected official, we like to waive a resolution. It doesn't have any teeth. This is literally drawing a line in the sand. We're not going to put up with it anymore. Whatever we have to do to get there, that's the route we're going to take. And there will be opposition. So be it.
Exactly. The Constitution's clear, Second Amendment's clear. Thomas Jefferson warned us of this day. He said, when injustice becomes law, resistance becomes duty, and I think it's our duty to stand up.
Yep. Any other questions or concerns? I mean, this is a first reading, but I think that this is a significant event. Obviously, folks are here for it, that we have this discussion and moving forward. We're going to work with everybody to make sure that we put out the best ordinance that we can.
The filing of the bills is becoming more and more frequent. And that's the scary part. to me.
Yes. Yeah, there's at least 4 bills that to my standard, I didn't like, but we definitely will keep people informed on that. Let me go ahead and read the first ordinance. That way we can at least get the first reading out of the way. Ordinance 2019, an ordinance establishing Marshall County, Kentucky as a Second Amendment sanctuary county, SASO. Section 1, title. The title of this ordinance shall be known as a Second Amendment Sanctuary Ordinance, or SASO. Section 2, findings. The people of Marshall County, Kentucky find and declare, acting through the Constitution of the United States, the people created the government to be their agent in the exercise of a few defined powers, while reserving the citizens the right to decide on matters which concern their lives, liberty, and property in the ordinary course of affairs. B, the Second Amendment of the Constitution of the United States, a provision of the Bill of Rights, drafted and introduced into the first Congress after the ratification of the Constitution by James Madison, states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. C, the right of the people to keep and bear arms and further protected from infringement by state and local governments under the 9th and 10th Amendments and the due process and privileges of immunities clauses of the 14th Amendment to the Constitution of the United States. Item D, Kentucky's Bill of Rights set forth as Section 1 of the Kentucky Constitution, protects the rights of life, liberty, worship, pursuit of safety and happiness, free speech, acquiring and protecting property, peaceable assembly, redress of grievance, and bearing arms. Section 1 of the Kentucky Constitution reads in pertinent part, all men are, by nature, free and equal, and have certain inherent and inalienable rights, among which may be reckoned. 7th, the right to bear arms in defense of themselves and of the state, subject to the power of the General Assembly to enact laws to prevent persons from carrying concealed weapons. E, the Supreme Court of the United States of District of Columbia versus Heller, 554 U.S. 570, 2000, recognized the individual's right to keep and bear arms as protected by the Second Amendment of the Constitution of the United States. Justice Anton Scalia's prevailing opinion in that case stated that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia and the right to use that firearm for traditionally lawful purposes, such as self-defense within the home. Item F, Section 1 of the 14th Amendment of the Constitution of the United States reads, no state shall make or enforce any law which shall abridge the privileges of immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. Item G, the Supreme Court of the United States recognized in McDonald versus the City of Chicago, 561 U.S. 742, 2010, that the Second Amendment of the Constitution was incorporated into the 14th Amendment and hereby made applicable to the states. Item H, Justice Thomas M. Cooley in the People versus Herbold, 24 Michigan 44, 1871, op-ed. The state may mold local institutions according to its views of policy or expediency, but local government is a matter of absolute right, and the state cannot take it away. And that the legal rule has since been known as the Cooley Doctrine. Item I, the right of the state to be free from the commandeering hand of the federal government has been recognized by the Supreme Court of the United States in Prince versus United States, 521 U.S. 898, 1997, The court held the federal government may neither issue directives requiring the states to address particular problems nor command the states' officers or those of their political subdivisions to administer or enforce a federal regulatory program. The anti-commandeering principle is recognized by the U.S. Supreme Court in Prince versus United States Supra are predicated upon the advice of James Madison, who in Federalist Number 46 advised a refusal to cooperate with officers of the Union in response to either unconstitutional federal measures or constitutional but unpopular federal measures. And the Supreme Court of the United States in Miranda versus Arizona, 384 U.S. 436, 1966, stated that where rights secured by the Constitution are involved, there can be no rulemaking or legislation which could abrogate them. Therefore, the right to keep and bear arms is a fundamental individual right that shall not be infringed. And all local, state, and federal acts, laws, orders, rules of regulations regarding firearms, firearms accessories, and ammunition enacted or promulgated that violate that fundamental individual right are violated of the Second Amendment of the Constitution of the United States and/or Section 1(7) of the Kentucky Constitution. Local governments have the legal authority to refuse to cooperate with state and federal firearm laws that violate those rights, and to proclaim a Second Amendment in Section 1(7) sanctuary for law-abiding citizens in their cities and counties. Therefore, through the enactment of this document, Marsh County, Kentucky is hereby a Second Amendment sanctuary county. Section 3, prohibitions. A, notwithstanding any other law, regulation, rule, or order to the contrary, no agent, department, employee, or official of Marshall County, a political subdivision of the state of Kentucky, while acting in their official capacity, shall, 1, knowingly and willingly participate in any way in the enforcement of any unlawful act as defined herein regarding personal firearms, firearm accessories, or ammunition. 2, utilize any assets, locality funds, or funds allocated by any entity to the locality in whole or in part to engage in any activity that aids in the enforcement or investigation relating to an unlawful act in connection with the personal firearms, firearm accessories, or ammunition. B, this ordinance does not regulate the lawful ownership, possession, transfer, or transportation of firearms, ammunition, or ammunition components. Only the contrary, this ordinance prohibits the enforcement of unlawful acts or the use of assets, Marsh County funds, or funds allocated by any entity to the county in whole or in part to engage in any activity that aids in the enforcement or investigations relating to the unlawful act. C, an unlawful act shall consist of any federal or state law, order, rule, or regulation which restricts an individual's constitutional right to keep and bear arms, including any federal or state act, law, order, rule, or regulation that bans or effectively bans, registers or effectively registers, or limits the lawful use of firearms, firearms accessories, or ammunition, other than a fully automatic firearm which is made unlawful by federal law. Any such unlawful act is invalid in Marshall County and shall not be recognized by Marshall County, is specifically rejected by the voters of Marshall County, and shall be considered null, void, and of no effect in Marshall County, Kentucky, and this includes but shall not be limited to the following. 1, any tax, levy, fee, or stamp imposed on firearms, firearm accessories, or ammunition not common to all other goods and services on the purchase or ownership of those items by citizens. 2, any registration or tracking of firearms, firearm accessories, or ammunition. 3, any registration or tracking of owners of firearms, firearm accessories, or ammunition. 4, any act forbidding the possession, ownership, or use or transfer of any type of firearm, firearm accessory, or ammunition by citizens of the legal age of 18 and over, other than pursuant to federal law background check requirements for transfer or purchases through the FFL dealership. or dealers. 5, any act ordering the confiscation of firearms, firearm accessories, or ammunition from citizens. 6, any prohibition, regulation, and/or use restriction related to ownership or the constitutionality, guaranteed lawful use, or carry on non-fully automatic firearms. And 7, any prohibition, regulation, and/or use restriction limiting hand grips, stocks, flash suppressors, bayonet mounts, magazine capacity, clip capacity, internal capacity, bump stocks, suppressors, or types of ammunition available for sale, possession, or use by citizens. Section 4, penalties. A, anyone within the jurisdiction of the Marshall County, Kentucky accused to be in violation of this ordinance may be sued in the District Court of the State of Kentucky for declaratory and injunctive relief, damages, and attorney's fees pursuant to KRS 83A065. Neither sovereign nor official or qualified immunity shall be an affirmative defense in cases pursuant to this section. B, any peace officer may enforce this ordinance. C, a civil offense against this ordinance is a Class A violation per KRS 83A065 with a maximum fine of $2,000 for an individual and $4,000 for a corporation per KRS 83A065 subsection 4. Item D, exceptions. The protections provided to citizens by this ordinance do not apply to persons who have been convicted of felony crimes or who are prohibited from possessing firearms under the federal law. Item 2, this ordinance is not intended to prohibit or affect in any way the prosecution of any crime for which the use or possession of a firearm is aggregating factor or enhancement to an otherwise independent crime. Item 3, this ordinance does not permit or otherwise allow the possession of firearms in federal buildings. Item 4, this ordinance does not prohibit individuals in Marshall County from voluntarily participating and assisting in permitting, licensing, registration, or other possession of applications for concealed carry permits or other firearm accessory, or ammunition licensing or registration processes that may be required by law. Item 5, in accord with KRS 65870, this ordinance is not intended to, nor does it in any way, regulate the manufacture, sale, purchase, taxation, transfer, ownership, possession, carry, storage, or transportation of firearms, ammunition components of firearms, components of ammunition, firearms accessories, or a combination thereof. Rather, this ordinance enforces and protects within Marshall County, Kentucky, the existing federal, state, constitutional regarding same. Section 5, servability. The provisions of this act are hereby declared to be servable, and if any provision of this act or the application of such provision to any person or circumstances declared invalid for any reason, such declaration shall not affect the validity of the remaining portions of this act. Section 6, effective date. Item A, the effective date of this ordinance, the Second Amendment Sanctuary Ordinance, or SASO, shall be effectively immediately upon approval by the Marshall County Fiscal Court. That's the ordinance, and as we discussed, obviously, we'll draft a policy to attach to that. And again, you don't think that the policy is significant enough. I don't think it is significant enough substantial enough to change the intent of the ordinance.
Like I said, I don't have a problem with what the goal is. It's how we get there.
Right. But do you think the policy, adding the policy before the second reading is a substantial change to the ordinance?
That would warrant you mean?
It's just a general question.
Yeah, I mean, we can make changes in
Okay.
between now and the second reading.
Okay.
Yeah.
That's what I
They
want.
won't be they won't be substantial. So,
Y'all have any questions?
No.
Okay. I know some of you have to get to work, so it's early. I appreciate your time for being here today and hearing this. Definitely, if anybody has any concerns or comments, reach out to us. We'd love to hear from you. But on behalf of the court, I appreciate y'all for being here. to stand behind this, this initiative as we move forward. So thank you.
Yeah, thank y'all. Tim, you thought they were here for your budget, didn't you?
They hadn't left yet.
Yeah.
Hey,
No,
Judge, can we take a recess
yeah,
for
we
a
can go ahead.
bathroom break?
Yeah, go ahead and take a recess.
Need a motion?
You got a motion?
Motion.
Second. All those in favor say aye. Aye. Motion carries. We'll go ahead and call court
Call
back
me
to
and
order.
Put me on speaker or something, so I'm not sitting there with y'all.
Under guests, let's go ahead and get to Randy Green, because I know he's, good morning, sir.
Morning, Judge, members of court.
Morning.
Well, I thought they came to see me.
Yeah.
I'm not gonna take up too much time. I've already had a big day. Basically, I just come to let you know, there's a lot of departments in this county that does a good job, really works hard and achieves goals. But there's been a lot of money invested in our sewer plants, sewer districts, and I want you to know, after $1 million, millions of dollars invested, the years invested, I know probably 3, when I myself was tasked with seating the board, and the 2 biggies was become self-sufficient and become compliant. Just want to let you know, I'm here to report that as of this past week, as far as I know, to my knowledge, all the sewer districts, Aurora and Graftonville 1 and 2, are 100% compliant. There are 0 violations. Our plant in Graftonville is completely rehabbed. It's running fully automatic, making pretty water, pretty drinkable water, Jason, in case you want to come by. And it's running 100%. And I guess I've always heard you ain't bragging if you done it. Well, I didn't do it. Look at these men back here. All I've done is kind of run my mouth and chair a board. But these guys have worked hard, and they put forth a big effort. We can't pay them what they're worth, but we do the best we can, and they've made what we've got, and they've brought forward what you asked for, and they've achieved those goals, and that's what I'm here for today, just let you know we're there. We're not stopping. We're going to expand. We're going to keep going. But it took a while. And the next time you ask me, step up, I'm going to think about it before I just jump right in there.
Yeah.
But
Don't say that. And it's going to be difficult. It's difficult enough to
That's
get
a bad
board
image,
appointments.
right?
Yeah, thanks, Randy.
well, you know, now that you mention it, we've got to realize that basically, as elected officials and appointed people, all we are is post turtles, Monty. You know what that is, don't you?
Oh, no. Is it?
Is what? Would you
is
repeat
this
that?
on-
Post turtles.
Just let me mention,
Turtles.
this is on video. So, no, I do not, but I'm concerned.
Well, it's not like explaining
Okay.
the last thing we explained.
Okay, good.
A post turtle is you're out walking through the field and you look and see a fence post with a turtle sitting on top of it. You've got to keep in mind that turtle didn't get up there by itself, and that's what we've got to keep in mind. And they ain't but 2 ways down. He's either got to have help or he got to jump. So while we're doing our job, we've got to keep that in mind. And we're
That's right.
all post turtles. We got up there somewhere.
That's right.
Now I'm trying to think if
That was-
I've ever gone by
That
a
was a lot
post with a
better.
turtle on
That
it.
was a lot better than where you thought it was going to go.
Yeah.
You remember the last time you. But anyway, guys, that's what I was here for. I just want to let you know that there's a lot of other departments in the county that does their job. This has been at least a 3-year effort, and we're there, and I'm proud of it. Is there any other questions that we have before I say shut up?
I know I've got, one, I do, to recommend, congratulate you guys and stepping up. I mean, these boards, there's so many boards out there. And then we have to have citizens from within the community step up and sit on these boards. That district, when I first came in the office, I mean, we were literally running it out of my office, the books, and it was in such a mess. To see where it is today and the hard work of Jonathan and Lendl and everything that everybody has done to get it where it's at, reorganizing it, putting it under one umbrella, one board. I appreciate you and the other board members. I know there's several of you on the board for stepping up and making that happen, because we couldn't have done it. You're exactly right. The turtle on the pole couldn't have got there without everybody involved. So,
Exactly.
but we're not out of the water. We're not 100%. As far as compliance, we're 100%.
Right.
We still have some other issues, and I want to bring that up to the court. One of the things that we went into is an agreement with the district and the school, and where we're at in that for months. This has been going on for several months, trying to get the parties together to discuss a bar screen, the where it was going to go. And my concern is that we've got till February 28th. The high school's permit is actually going to expire February 28th. And that's a little over 2 months.
Exactly.
We've had the engineers identified and through a mediation process. We've had the engineers identify a local engineer to sit down with all parties. All parties agreed, but that individual, due to conflict of interest, because he knows all the parties involved, chose not to participate. And both parties back and forth trying to get somebody to come in and sit down and mediate this issue of a bar screen it's one meeting, it looks like it's going to be successful, and then for various reasons it just doesn't pan out. So what I have done, and Mr. Davis, Joe, is a citizen in this county, and Joe's a Marine from Korea, and in discussing with him over the past years, he's always up here in court. Come to find out, his son, Jeff Davis, actually is an engineer, and he is the division manager of rehab and operations of Charlotte Water in Charlotte, North Carolina. When we went back to the square one to where they wanted to leave it up to the engineers to find somebody to sit down with all three parties, I realized that Joe and I had a conversation. His son had worked for this Charlotte Water, and I called him and I said, are you coming in to see your father for Christmas? And he said, yes. And I said, is there any way that you can sit in with all three parties involved so that we can have somebody who's an expert on waste management to sit down and hear the parties out in a mediation? And he got back to me and he said, yes, I'm coming in to see my father, and I would love to sit in and help resolve this bar screen issue with these parties, because we're running out of time. And two, the permitting, things of that nature, the paperwork that's got to be done with Department of Water, all this thing takes time, and we've got less than 2 months, or a little over 2 months, to get this resolved. So Jeff is actually coming in. I put out correspondence to all the parties. The school, to this point, they're not coming. They've said that they're not coming, but I think that for us, it's important. For me, it's important to get somebody at a meeting, at a table, make them available so that everybody can sit down and have these discussions. I don't want to wait till February 28th and nothing is done and the school's permit is expired. And then they're going to be looking potentially at fines, just like what we were. When Department of Water put us in fines upon us, and they put us in an agreed order. I mean, I remember on my birthday in 16, went up to Frankfurt, got slapped on the hand, and got fined. That's how they work. And we don't want to get to that point. So Jeff is coming in on the 27th. He's going to be here on the 27th. I've scheduled a meeting at 11 o'clock in Draftonville at the chamber. Any of the parties that want to show up, they can show up. He'll be available. He is a licensed engineer in North Carolina. He does understand the water and wastewater engineering issues. That's what this is. It's an engineering issue. and his hourly wage is $150. I don't expect the meeting to last an hour, but I would ask the court that we would, you would give me permission to hire him for this meeting and cover his expenses. And what I would suggest, if the court would entertain, is you make it a 2 hour in case of it, all parties do show up and we do go to 2 hours. But I do not expect this to last more than an hour. But we have to have somebody sitting at the table. We've got to get all the parties together. I've called Department of Water, and it's the regional office. Here's the thing, we have a public service available now. What the court did, just to give a short summary, the court actually partnered with the district and the school. The school, under their permit, it states, they shall tap on when a public service is available. It was available, but it wasn't the best solution going up towards 641 and 68. We partnered with them. We've got this public service line now active, and it is available. Or if you look at it back when their permit said that when it is available, they have to tap on, we gave them the time to get their affairs in order so that they can tap on. I can't speak for Department of Water, but from my understanding, if that public service line is active and it's ready for them to tie on, then February 28th, they could come out now. That's my intent, is to call them and advise them that we are ready, the district is ready for them to tie on, but this issue has not been resolved, and their permit expires in a little over 2 months. I don't know why it's not getting to where we need to get, but I think we need to get Jeff here to at least try to mediate this issue. So that's the only thing that I see that's holding up the success of this district, because the public service line is working. Several folks have already tied into it, and you guys are moving forward. You're doing an outstanding job, and we're actually even looking to go in the other direction.
We were actually, the contractor was able to stay within his bid. And, all contract jobs, there's a contingency that's built into that. And we were actually able to use contingency funds that weren't needed in the original project to expand even further. And by doing that, we were able to dismantle another failing little plant up to Memorial Gardens. So we got up there and we've got another plant. And by going up there, we went past the lagoon. That's 2 more off the system.
Yeah.
So we're really knocking these out quick, and the money's being spent real well. One of the issues with not getting the line hooked up at school is there's so many permits that has to be filed by the engineers that they're timely, and they're going to expire. The contract with the contractor himself, he was there. He was in Draftonville. He was working on site. We couldn't come together. He's gone. There's going to be remobilizing. I mean, it costs money to bring this equipment in. The fact is, sitting there ready to do. I'm not here before you to argue my point one way or the other with the issues we have with the school. But I will say that I'm the one that said, no, we're not going to tie this system on, tie the school on without some type of pre-treatment. I talked with Lindell, and he advised what we needed would be a bar screen. And the reason you say, well, people can flush things at houses and they can discard things at houses. How do you control that? Does everybody get a bar screen? Well, no, they don't. That's not practical. But what we've got at the school is a known. And if you don't act on a known, you're just accepting whatever's coming. We know what comes from that school. We know what's taken out of their bar screen that they have on their plant right now. They have one, and it's empty. And I've got pictures of what comes out of that bar screen. Now, I can't knowingly allow that to come down that new line to $50,000 worth of pumps sitting down there and tear them up, not knowing it's going to do it. And I know it's going to. And that's where we ran into a problem, is there has to be a bar screen, protect our system. It has to be on school property where it needs to be, because there's such a term as suitable site. We don't have a suitable site down on our line. It's 12 foot deep, 14 foot deep. You're talking about confined space. You're talking about 2 men. There's a lot of OSHA regulations getting men down there to do a 15-minute job. We put a bar screen in our plant, and it takes, 15 minutes to clean it out? We're done. And that's all we're asking, is that there's a bar screen put in on the school where it's shallow, in the right place, 15 minutes it can be cleaned. We've even offered our own employees, if we could be reimbursed for our employees' time, we would send employees over there to take care of it, and the school rejects that. But we're about to get into a serious problem. Commissioners, I just want you to know that midnight the 28th, the permit's going to expire. And I don't want to be the one thrown under the bus because of it. I'm doing my job to protect my system, and I want you to know that up front. You're talking about less than $50,000 on this fix, on a $3 million plus project. And I don't understand why it's not already done, but it's neither here nor there. I hope our mediation will settle it. I don't know what's going to happen if it doesn't. If the permit expires, they've already got a failing system there. It is failing, has been, and it's going to be shut. And that's going to affect school. I mean, it'll affect, we're talking about a health issue. We're talking about possibly not being able to operate. So, I don't know. I'm speculating. That's not my job. I'm just saying I'm not going to let them mess up our new equipment. That's also my job. And I'll stand my ground until a judge in court tells me you shall do this, and at that point, that's what I'll do. But until then, we're going to stand our ground and see what happens. Other than that, everything's running good. We have new customers signed on. The system's working great. We're picking up new customers daily. There's a lot of people that's not tied on. We haven't pushed it really hard. Maybe I shouldn't even say this here. But when we were tying on, it was tax time. We had Christmas season coming in, a lot of expense this time of year. And there's a lot of people that's going to be a great expense for them to tie onto this system. So we're not really pushing until after the first of the year, when things kind of settle down where people will be able to afford to get onto it. We don't want to hurt anybody. We want to help you and make it better. That's why we haven't really heard us go door to door. But
Right.
Is there any other questions on this?
All right. If not, I appreciate you coming in and giving us an update. And if I can get the court to, it's a new business item, but under G, but if I can get the court to go ahead while we're talking about it, to entertain a motion to cover Mr. Davis's expense.
I'll make that motion, Judge.
Is it for, I'm sorry, is it for $300?
Yeah, for
Up
2 hours,
to-
150 hours for
Yeah.
2 hours, yeah.
For a second. All those in favor say aye. Aye. Any opposed?
I'm going to vote no because I think mediation only works if both parties are present, and according to Mr. Lovett, they will not be there the 27th.
Correct. And they, just so the record states, they've been invited to bring the person that they want to mediate, which is an attorney. So, but again, I want to express this, if we don't get somebody to the table, I want to put it on the record that the public has been made aware that this public service line is, and it's operable. And their permit says they shall tie on. So we can't sit around and wait until February 28th. So motion passes. Appreciate it.
Thank you for your
Thank
time.
Move on to item D. York. Tim York. Good morning.
Morning. Got my 2020 budget and deputy hire here. I sent all of you a copy of it. Estimating receipts to be $10,070,000, disbursements to be $9,860,000, excess fees of $210,000, and deputy hire at $600,000. And I'll need a separate motion on each so that the auditors don't have trouble finding it.
Is that, do we want to discuss, Tim, what you and I discussed as far as?
I don't think so.
Okay,
I think you and I, we've agreed to disagree, and I think
all
that's,
right,
we'll just
all right.
agree to disagree again.
okay. And just so that I understand, that increase on the 600,000 is not for that?
Well, that's why I put it in there, but it's one of those things that, I generally won't spend up to my deputy hire anyway, so.
Well, I guess the reason why I ask is because I know the intent for your office to find another location. Some of those monies could go towards the purchase of potentially another location. So that's why I ask. It's about what, 20?
20,000.
20,000?
Yeah, but I've got microfilming that I can do, that's.
So are you going to use that for?
Probably will. My excess fees, I'm budgeting 210. Last year, I turned in 280. So I always budget conservatively. And I was county treasurer at one time, and I'm sure Erica will appreciate, whatever I budget is excess fees is what she has to put in her budget. She would much rather me under budget
Sure.
and then surprise positively than do it the other way around and then come up and say, well, I thought I'd have 280, but actually I'm going to have 230, and you're going to have to come up with $50,000.
Right. And I think 205, 210, what did we budget? 210, yeah. So that's something that we can look at when that time comes. Sheriff, when you find out your information, we can use those excess fees to help potentially in that purchase.
Generally, what I try to do and what's been important, to me, again, I was county treasurer for 14 years, so the fiscal court pays the fringe on my employees, and something that I've asked Des again to get me, I want to know that I'm covering the fringe. I'm wanting to feel like that I'm carrying my own weight, that you guys are not subsidizing me, that I'm paying, even though you pay the fringe. And there's probably been years in the past, you look back 5 years ago, and we had a bad year where you may have very well had to have subsidized me, but probably for the last 4 years, I've actually subsidized you a little bit.
Right.
I'll pay more than what my fringe burden is. So I think last year, my fringe burden was about 244,000, where I turned in 283, so.
Okay. All right. That's all I wanted to ask.
All right.
There's two motions.
Motion to approve the county clerk's budget.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. And then we'll need a motion for the increase. Where's it at?
So move.
The annual order setting maximum amount for deputies and assistants. He's going to increase it to 600,000.
Second.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. We'll go on to correspondence, personnel changes. I'm sorry. Wait a minute.
He's sitting there waiting for it.
That guy, yeah. We'll go on to guest, Andy Lepstow. Good morning, sir.
Good morning. This should take no longer than about 45 minutes.
Okay.
So we'll try to go quickly. Judge Neal asked me to show up and address the court, let them know what we're doing as far as the 2020 census, where we are, what kind of things are going on in the community. Just as a little background, because I know, at least for me, it's been about 7 years since I had high school civics. So as far as, that was like, whoo, went real fast. Well, everybody took this crowd that came up for me. I can't really go that route. Mm-hmm. But just to give you a little background, just to make sure everybody understands as far as what the census is, the Constitution mandates that every 10 years the U.S. government does a census. Primarily, that's for representative reasons, determines how many House seats that we have. It also requires us to redraw those districts. But in addition to that, there's a whole lot that is determined from that information. For one of those, it's about $675 billion a year in federal aid. So that's going to be schools, libraries, roads, all kinds of things that come to us. if we don't have an accurate count in our community, we're not going to get our fair share of those funds. So you're talking about quite a bit of $675 billion a year is how much we're talking about there. We want to make sure that we get our share of that. In addition to that, a lot of that census data is used by private industry to determine where they want to develop, where they see population trends. So if we really want to put our best foot forward as far as economic development goes also, we want to make sure that we're accurately represented as far as all of the people that are in our county. So even though this is a federal program, at the local level, we still are involved quite a bit. Back in the summer, we completed the LUCA program. It stands for the Local Update of Census Addresses. It's just one of those nice acronyms that sometimes people throw around. They don't really know what it stands for. But essentially, what we did in that situation is the census sent us a list of all of the addresses that they think that we have in our county. We were able to go through, correct some of that stuff, add some addresses. You know, we know through our building program, we know where development is going on. So there's some addresses in there that the census didn't have. Primarily through that program, we just want to make sure that when the census sends out all of the census questionnaires, that they send it to as many different residences in the county that we can. We want to make sure that every single residence gets that questionnaire. In addition to that, we have formed a complete count committee. And the goal of the complete count committee is really to involve local community leaders, our schools, our libraries are working it. We work with our cities. Anybody that we could use to get the message out of what the census is, what's going to be involved with the census, what kind of questions, what you can expect, trying to get that message out as much as possible. We had a booth at the Who Fest. We had a lot of people come by and ask some questions, some interesting questions, a lot of questions that I didn't know the answer to. We had several people from the census that were there to answer those questions. So that really gives us an opportunity that when the census comes around on April 1st, that we're ready for that census. We want to count every single person. We count them one time, and we want to count them where they are. Oh, yeah, the one other thing I wanted to bring up was this year is a little unique as far as the census goes. Previously, everybody received the census questionnaire in the mail. You had to fill it out. Some people received this long form, and it was like 25 pages. Some people had an issue filling out that. Then you had to put it in the mail and send it back. It's a long process. This is the first time that we've done the census, or that the government's done the census, where we'll be able to respond online. And one of the goals of this complete count committee is to make sure that what they call the initial count, or the initial response rate, is as high as possible. Because what happens after that initial response rate? So everybody gets a census. Hopefully, best case scenario obviously would be 100% of the people turn it in right away. Well, that's not realistic. So what happens after that point is the census will send out census enumerators, and they will go house to house to every single residence that we turned in an address for that said somebody was there. If they have not responded either by mail, phone, or online, they'll actually have census takers go to those addresses and sit down with those people and help them complete the census. So that's one thing that's a little unique this time. And like I said, one of the big goals of us as a community is to make sure that as many people are aware that that census is coming up, so when they see it, they know what they need to do, where they can go to complete it if they don't have access to a computer in their home. Come to the library. I think the schools are going to be doing some things. So that's really our goal. The only other thing that we can really do as a community is get the message out. We have to hire, or the census, I shouldn't say we, the census has to hire a tremendous number of people on a part-time basis, or on a temporary basis, I'm sorry, to go out and canvass these areas and look for people and make sure that everybody's counted. Right now, we previously, our community, it depends on the community as far as how much they pay, but our community was, I think, at $14 an hour, and they've actually raised that to $19 an hour and 58 cents a mile. So for every mile that somebody that would have one of these jobs that's going to drive, they're going to get reimbursed 58 cents in addition to the $19 an hour. So that's really a message we want to make sure we get out to. As of right now, the last time I checked, Marshall County, we were doing pretty well as far as the number of applications that they were hoping to receive so that they can get the number of hires that they need. Percentage-wise, we were ahead of where we wanted to be. Of course, that number can change. We want to make sure that we really encourage as many people to sign up that would be interested in that as possible. So I am here for any other questions that I will probably not be able to answer because I do not work for the census.
No, I appreciate it, Andy. I think an update, that way folks in the community know that it's going to be here before we know it. It's already here. But
Yeah.
Come April, it's important that we get it counted.
Yeah. There's one other thing that I do want to point out because we've heard this a lot. Every bit of the information that's individually identifiable, either an individual, a business, a household, all of that information is protected by Title 13 under the U.S. Code, so it can't be released. So a lot of people think, well, they're gonna take this information, and they're gonna come to my house, and they're gonna find out all this stuff about it. That stuff is protected for 72 years, and it's not released until at least 72 years afterwards, and then it's only for historical purposes. So all that information is protected, and I want to make sure that message gets out too. It's not, nobody can look up an individual's responses to their census questionnaire, not law enforcement, the FBI. All right.
Thank you. We'll move on to correspondence, personnel changes.
Judge, I just wanted to, before I read these, I know this seems redundant. I know we have questions. Some of these approvals we had already made from court, but we found that talking to auditors in the past years, they recommended that we just read these changes every month into the court record so that they're part of a court document and official. So I just kind of wanted to make that clear before I read the personnel changes. So this is November 2019 personnel changes. Caitlin Jones, deputy jailer, part-time to full-time, effective 11/1/19. Kristen Jones, 911 dispatcher, full-time new hire at $13.70 per hour, effective 11/1/19. Kevin Goodson, 911 dispatcher, full-time new hire at $16.75 per hour, effective 11/1/19. Nick Spear, sheriff deputy, rank pay removed, pay sheriff per Sheriff McGuire, effective 11/1/19. Nicole Ford, road department, wage increase from $14.96 to $17.96, effective 11/1/19. Alexandria Belcher, 911 dispatcher, wage increase from $13.43 to $14 an hour, effective 11/1/19. Morgan Lemaster, Parks Department, wage increase from $12.15 to $13.75, effective 11/1/19. Brittany Heath, Parks Director, wage increase from $43,031.25 to $49,608, effective 11/1/19.
All right, we'll go on to item B, KRS contribution rates. I'm just going to read this to you. The KRS Board of Trustees met on December 5th and adopted Sears employer contribution rates for the fiscal year 2021. These rates are effective July 1, 2020, and were set in accordance with the House Bill 362, which was enacted during the 2018 regular session of the General Assembly. House Bill 362 caps Sears employer contribution rates rate increases up to 12% over the prior fiscal year for the period of July 1, 2018 to July 30th of 2028. Employer contribution rates for fiscal year 2021 are effective July 1, 2020. Sears non-hazard 26.95% and Sears hazard 44.33%. Please note that the employer contribution rates are subject to change depending on the future actions of the General Assembly. So that's just an update on the increase on the retirement contributions. Old business, approve the minutes December 3rd meeting.
Motion to approve.
Second.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Under new business, the building inspector agreement, did we get a copy of that? You guys should see that. Kat's fine with it, so if y'all want to have a discussion on that. Do you want to update what the auditors basically had said, where it was originally contracted and what they had recommended?
Yeah, so this was back when Emily was treasurer, prior to me, even when Judge and I were here. There was a discussion about Mr. Spears providing the building and electrical inspection services as a contractor as opposed to an employee. It was recommended that he was moved to an employee. So at that time, he became an employee. So we paid his all of his FICA match and all those things. Since then, we've been told by auditors, and also I felt like also on our end, he falls under that contractor 1099 service for the county. We don't dictate his schedule. We basically don't control anything he does. He just provides those services. And I think I think what we found is this is a very a good asset to have in our county, as we have a lot of things going on, especially down in Calvert City. They get their electrical inspections quick, and I think it keeps people here. So we felt like this was a benefit to put in place. And Judge and I met with Mr. Spears, and he was fine with going back to a contract. in a 1099. And he actually wrote this up. I typed it up, sent it to Jason. Jason made some just format changes, and but everything in here is still what Mr. Spears has presented.
Is there any?
I just noticed one thing that we need to change on that is under section 5, where it talks about his compensation.
Yep.
Except for those items specifically enumerated in section 4 above and pursuant to section 2. That's where his compensation.
Once you get that, I can sign the other one once you get me a corrected copy. Is there any discussion on that?
I move we approve with that change.
Second.
Second, all those in favor say aye. Aye. Any opposed? Motion carries.
And just for, this will go in effect January 1, so we'll continue to pay him as an employee through December, and then beginning January 1, they'll submit bills, the fees for him, we'll calculate as 80%, effect January 1.
Item B on the new business, board appointments for the Tourism Commission Board. The appointments, Tristan Smith, and Heather Meeks.
And those are from
Yeah.
Chamber.
In the Lodging Association. So
Lodging
what they do is they send, the ordinance directs the associations to send the names, and then I make the appointment, and I present it to you guys.
I move we approve the appointments.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Item C, the PACRO grant. Again, this is just to let the court know that we're bringing in $45,000 for a PACRO grant for the redundancy of fiber out at Southwest One. So those monies will come into the general funds, and then they'll basically be going back out to the IDA for that project. So they're going to be starting that project as soon as they get the check. So that's good. We'll have, I think it's going to be triple redundancy out at the Southwest One as far as internet service and fiber. But I don't know if that's an action item. It's just to update you that it's coming in to the court. So
It's on the budget amendment.
it's on the budget amendment. There you go. All right. So item E, 2020 holiday schedule. Everybody had a chance to take a look at that? We just need to, if there's no changes, we just need to approve the 2020 holiday schedule.
Motion to approve.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. We'll go to item H, appropriations transfer. We already read it. Oh, I'm sorry. Yep, I did skip that. Go back to item F, ordinance 2019-14 budget amendment, first reading.
Okay, ordinance 2019-14, an ordinance relating to the annual budget and amendment thereof, whereas the County of Marshall has received additional funds, now be it ordained by the Fiscal Court of Marshall County that Section 1, the annual budget for fiscal year 2019-2020 is amended to A, increase or decrease revenue accounts as follows. 911 fund cash balance July 1, $50,121.42 down. E, 911 funds transferred in, $50,121.42. Occ tax funds, occupational tax funds, cash balance, July 1, $376,222.73. Occupational tax funds transfers out, $146,971.78. ABC fund cash balance, July 1, $18,145.65. Building inspection cash balance, July 1, $1,143.52. PACRO grant, $45,000. Court rental, or AOC reimbursement account, $19,192.73. The general fund surplus equipment sales, $1,716. General fund insurance proceeds, $16,364.01. General fund miscellaneous, $397,198.90. General fund cash balance July 1st, $1,006,072.66. General fund bond sale proceeds, $7,187,140.78. Road fund surplus equipment, $2,031.10. Road fund insurance proceeds, $3,600. Road fund miscellaneous, $8,073.95. Road fund cash balance July 1st, $15,101.94. Jail fund cash balance July 1, down $96,850.36. Jail funds transfers in, $96,850.36. Grant fund cash balance July 1st, $192,641.08. Animal shelter donation account donations, $32,890.04. General fund insurance proceeds, $39.48. Grant fund KIA for the MCSD2 expansion, $375,299.99, for a total increased revenue of $9,554,811.30. B, increase expenditure accounts, general fund capital projects, $393,458.40. Sheriff's auto expenses, vehicle lease, $4394.85. The coroner's office equipment, $64.94. Maintenance lease payment for the fire, $4,800. Maintenance building and grounds for the general fund, $19,192.73. OEM maintenance repair, $2503.16. Ambulance service equipment, $1545.50. Southwest One expense item, $45,000. State auditor, $6,072.66. General fund reserves, $2,083. General fund investments, $8,187,140.78. Road fund reserves, $28,806.99. KIA project, $192,641.08. OTA reserves, $229,250.95. Animal shelter donation leases, $5,992. Animal shelter donation reserves, $26,898.04. ABC fund reserves, $18,145.65. Building inspection reserves, $1,143.53. Sheriff's auto expense vehicle leases, again, $39.48. And the grant fund, KIA, $375,299.99, for a total increased expenditure of $9,554,811.30. Section 2, the amounts added to the revenues and expenditure accounts in Section 1 are for governmental purposes approved by the Marshall County Fiscal Court the 16th day of December 2019.
All right, appropriations transfer, item H.
Okay, these are all within fund transfers. At the bottom, you'll see we do have a transient tax transfer that needs to go to the tourism department. It's $20,413.53.
Payment of the bills. Oh, I'm sorry.
The move we approve.
Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. Now, item I, payment of the bills.
Motion to pay the bills. I believe I've paid the bills every time this year.
You're a good man.
Second, all those in favor say aye.
Aye.
Any opposed? Motion carries. We need a motion to go into executive session for litigation,
So moved.
personnel.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries.
Move we adjourn.
Gotta call it back to order first.
Move we call it back to order.
And adjourn.
Now you can adjourn.
Second.
Second.
Is there a motion? All those in favor say aye.
Too late. It's done.
Carries.
We thought about it.